First of all, thank you very much for having us. This is a fantastic panel that I've seen so far. Very talented people. And one thing that I want to note is that when I look out right now and reporting, I'm sure that the rest of us here sitting at the table say that this is a continuing growing industry. It's challenging and competitive, but there are lots of opportunities going on. I report on them every day. I was sitting here in the midst of in the back, it's getting more news that potentially opens up more opportunities for those that are continuing to seek opportunities in the fields that you all are seeking. So I want to start off, and we can go ahead and start here with Paul, and we can move down the line. One of the things that I find most interesting for those that work in the industry is that job career paths are not always, I think, what we plan on. It's interesting, certainly as a member of the media, I've seen, I know one member that's a Hall of Fame writer that was once in taxidermy, and this seems like a very odd career path for one to take. But most people have a particular, if they're involved in sports, they may have a particular sport that they're interested in. And many people, of course, don't wind up going to their given sport that they like or a career path that they may have anticipated. So I guess I'll start with Paul, and we can go down the line. How did you get your start in sports law?
Okay, so is Professor O'Fallon still at the law school? Yes. He is, okay. So when I was at UCLA, I ran track, and I knew that I wanted to combine kind of my love of athletics with a long-term career. So when I ended up going to law school, I met with Professor O'Fallon, who at the time was the rep for the Pac-10. At the time, he was the University of Oregon's rep for the Pac-10, kind of the relationship manager. I don't know if he still does that role he still does. And I said, I want to be a sports lawyer. And he said, there's really no such thing as sports law. It's really various areas of substantive law applied to the sports industry. And he said, if you want to be a good sports lawyer, why don't you try to be a good lawyer first? And so that was my introduction to that path that I embarked on. I don't know if we can do more than the introduction. If we want to kind of talk about the total immersion or literally just the first piece.
No, I think we have a little bit of time.
Okay. So from there, O'Fallon introduced me to the class rep process, and I became the first-year class rep at the University of Oregon. And at the time, I met one of the folks who was an alum of the University of Oregon at a 1L class rep meeting, and I said, boy, I would love to work for Nike someday. He said, okay, well, when you go through law school and you decide you want to work for Nike, you call me up and you let me know. And so I went through 3 years of school, and I clerked at the summer associate bits, and I graduated, and I reached out to this lawyer, and I said, hey, I would love to take you up on your offer to meet someone at Nike. And so I said, sure, no problem. You'll get a call back from someone very soon. Sure enough, I did. I got a call back from the general counsel at the time, Monty Stewart, who's since retired, and he said, yeah, why don't you come on in and talk to me, and we'll kind of introduce you to Nike. So I went in, and I had this very informational interview with Nike. Clearly, I was fresh out of school. They weren't going to hire me, but it was Lindsay Stewart and Paul Kelly who went on to succeed Lindsay Stewart as general counsel, and both of whom are now no longer with Nike, but were long-time Nike lawyers. And what they said during the meeting was, how do you know, boy, I'm blanking on his name, this is terrible. Mr. Smith, and I said, well, I met him at a 1L class meeting, and they told me, Smith is Knight's lawyer. He was the lawyer that helped kind of set it up, and he was the guy for Phil. And so when he asked us to meet you, that's how I got in. So my path into what really became my first sports job was very benign, and I kind of fell into it purely by luck. So that's how I got started.
When I went to law school, I had no idea that, is this right? When I went to law school, I had no idea that I wanted to work in sports. It wasn't even on my radar. I had been working as a paralegal personal practitioner in Beverly Hills, doing primarily litigation-related work when he threw me out and made me go to law school. And that's true. Maybe I applied, got accepted, and moved up on the city within 3 weeks and started law school. But, so I didn't even think about it. And that was after years of trying to get into sports or entertainment, but ending up on the business side of that and never really breaking through the way that I wanted. So I went to law school and came out as a litigation associate at a firm in Phoenix and had been doing that for 4 years, doing commercial litigation, personal injury with an emphasis on medical malpractice and wrongful death claims, and it was okay for me. It was just all right. Right about that time, the WNBA started, and I was a college basketball player, and so from that moment on, I like to think about, well, there got to be ways for me to merge my practice with my passion for sports. And at the time, the woman who I practiced at the same firm with my first year of practice, she was a transactional associate. I found that she was the general counsel for the Suns. And so I called her and asked her how I could get into doing what she does. And she told me I was completely unqualified, that I would need to be a transactional attorney. And I said, awesome. Yeah. So, I would do what it took to do that. First, I researched the different aspects, what the opportunities were, decided I'd be in-house with the team sounded the best to me. So I researched and found out what firms in Phoenix represented the sports teams there, and got interviews with both of them, and got an offer from what is still the Diamondbacks outside counsel firm to start over with them as a transactional associate. And about a week after they made the offer to me and I accepted it, they asked me to come in and talk to them. And I was terrified. I don't know what could they possibly want. I hadn't started yet. So I went down and they told me that my friend who's general counsel for Suns was leaving, and asked if I wanted to interview for the job, and had just been told by her that I was completely unqualified. I said, of course, please sign me up. So they set up the interviews for me with the Suns and Diamondbacks, who at the time jointly owned, and brought me into the firm as I went through the interview process. And I didn't get the general counsel job, but they did decide to create an associate general counsel job at that time. And that was just a little over 14 years ago now, and that's how I initially had it.
That's a big story. No, mine's sort of starts the way Paul described. I think growing up with switches as I went to law school. So what would you want to do? I would say I want to practice in sports. I took a sports law class my 2L year, and that was the premise of the class. Again, that there's no such thing as sports law. And the teacher was given the general counsel for the previous iteration of women's professional soccer. So the league started up right after the big World Cup back in 2000 or whatever, and he had a chance to practice there. And that's what he pressed on all of us was go be lawyers and see what doors open. So I practiced. I worked for a year for a federal judge in Phoenix, and then spent 4 years at some firm in London, and then here, Stolberg's downtown. And really, until the break, I had no contact with sports. It was just transactional law, ranging from $1 billion junk bond offerings to little startups, corporations for somebody with a good idea, and everything in between. But just trying to get the skills I could. And so this is actually heading into 2008, 2009. The economy is not great for a transactional lawyer or for lawyers in general at all. So I just would try to hustle where I could, and got involved in bankruptcy and just found myself one day a transactional lawyer, the next day appearing in front of a bankruptcy judge. When in fact, representing a client in bankruptcy hearing, and a witness gets on the stand, and I object to the first question. that was asked by the other council, the bankruptcy judge, went to me, and she goes, you know, we don't do that here, but I think you're right. So just jumping in and doing it. And, you know, in the process, I got to do a little bit of sports work for an owner of some NBA league teams who was selling off his interests, but nothing too substantial. And my first contact with sports opportunity was, you know, a job listing from the state bar website on a Sunday night in 2010, and it was just, you know, associate counsel for the Portland Trail Blazers in Rose Garden Arena, it's called the time, and I just applied. I mean, I couldn't believe it because in my mind, these were the jobs that always just went to somebody's, you know, flunky nephew or niece or whatever that just sort of falls into it, which clearly is not the case. You're Paul. That was sort of funky, but so I just applied, and then at that point it was just all the things you learn in you know, career development class. Like, okay, we'll find out who you know. And so I just asked around who knows anybody at the Blazers, and I had a really good friend who was serving on board with our former chief operating officer, and so I was able to get my resume up the top and just went through the interview process. And at that point it was just interviewing well and just trying to, you know, put myself out there and separate myself however I could from other really qualified good people, and I was able to get the job. And you know, one of the things I asked later, you know, years later, talking with the human resources people, and because I knew that I knew some of the other finalists, and I said, you know, why did you get the job? And you know, they talked about just, you know, fit and some of these other things. But they said they remembered in my interview how I was able to take a bankruptcy story and make it relevant to sports. And I maybe touched on a tiny bit of bankruptcy in my practice here at the Blazers, but I was able to just sort of display a willingness and ability to try something new and do it well. And I think, you know, whether you're interested in sports law or whatever you go do, you know, if you can exemplify that and communicate that, you know, that's what people need from their employers. So that's how I first started. And the former general counsel, who, you know, was my boss, retired in October 2012 after 20 years, and I, you know, at a time when new management, Chris McGowan, and some of the other folks were coming on, and got a chance to stay on as general counsel. So I've been doing that for the last 18 months or so, and it's been a great experience.
This, you know, Ben, that all of us have touched on this, or this panel has touched on this, is starting off with the fundamentals and then being able to move and basically adapt to your situation, and you come upon something and you wind up kind of where you're at. I mean, sometimes it's planned and sometimes it's good fortune. But you brought up something, you said the bankruptcy situation and using it now. So to the panel, what skills and traits have you developed that helped you have your success in your position? What is really, as you've gone along, has been kind of an undercurrent that has been kind of, I would say, a fundamental across wherever you've been in your career?
I was going to say we shift, maybe we should somebody else they start. Unless you want me to start again.
Oh, we'll loop back.
There you go.
Okay. And then we'll start working backwards and counterclockwise. Yeah. So I think I've touched on this a little bit, but you know, I think there's so much work that has to get done, so many different kinds of work, and you know, I think working in-house is, you know, a lot different than working at a firm. You know, the economics are built on hours billed, and that's how the money comes in, and you still need to work hard and be efficient and all those things. But you know, by the time someone wanted to pay, you know, a fresh out of law school person, you know, $300 an hour or $200 an hour, whatever, to research something, is because the answer was really important and it needed to be right. And if it's not going to be right, all the risks have to be really well considered, or you know, there's a lot of money on the line, and so this contract or this deal has to be super diligent or, you know, papered, you know, extra carefully. And And, so that was the environment that I grew up with at firms, and then transitioning over here to the in-house side, there's not time for that. And so being able to shift quickly to a place that values and puts a premium on good decisions, good thinking, efficient thinking, risk spotting, and knowing what matters and why, and do you need to be 100% right or is 80% right? Knowing, and then also just kind of knowing when we need to go talk to somebody else who has more expertise. A little bit more just on to the next thing. You're in a meeting, you're on a call, you're looking at a contract, you're talking to somebody, something falls out of the sky, and we'll talk about some of these other things, but you think your day is going to be spent doing something to do with licensing or real estate aspect, and then a big employee that just falls on your lap because it's a business full of people making decisions that aren't always perfect, and so just the ability to just adapt and apply good thinking and good skills, and usually I'm not the final decider on something. I mean, somebody else is, but they want my counsel, and so being able to communicate, understand what's important, and communicate it well to somebody who doesn't live in the legal world and doesn't want to understand the legal world every day, but wants to know what matters to them. So just kind of taking this world that we live in and putting it down to its essence for somebody.
That was a really good answer. I should have gone first. I'd say, it's probably going to mirror on what you said, but
You're really better at that. I just said it.
I'm sure your just as good at maybe better. It's just you. But time management, I'd say certainly, in my case, I have the ability to exercise the fine art of delegation, which is important, and it also goes to time management. Prioritizing, we have to be able to prioritize. Integrity, so above all else, and learning to listen to your instincts, and then that speaks to what you said about knowing when you know and when you don't know, or knowing when there's something there, even if you're not quite sure what it is. Very important, and learning to listen to and trust them. And also courage, I think, is important, because it's not the easiest thing to go into and tell them, you really can't do what it is you want to do. So courage and a certain degree of tact. And I would say confidence tempered somewhat by humility.
Should have chosen to go last on this one. I like pragmatism. I'm a big believer in not over-lawyering things. I am, Ben and I both, I was at Stolbery's. It's a fabulous firm. It's the big firms here. We had someone from Schwab here earlier. Dave's right for a while. When you're in an in-house position, you are in a much more fluid situation. So you may have an agreement that, let's say, is $100,000. That's a small deal at the time, and so you might spend a heartbeat on it, where an outside lawyer would be, trying to dig every comma. We're going to argue about venue. We're going to argue about integration clause. We're going to argue about the notice provision. I don't care about those things. I'm really looking for two things. I'm looking for rights acquisition and downside protection. That's what I care about. When I look at stuff, I'm looking to see what can go wrong. Okay, because we are designed to help mitigate problems. That's what we do internally. We're trying to help the business move forward without it coming back to bite us later on in the store. My goal, by the way, my goal for panels is two things. One is to not say something silly, which I've already done because I forgot someone's name, and not to swear. So far I'm good, okay? But it comes back to bite you, right? And that's where someone comes back to the three of us and says, hey, why did you let this go through? We have this issue. Especially if you don't raise the issue. Now, you can raise the issue with your client. You can say, look, here's the risk. Here's the downside. We can't protect you. If you want to continue forward, you can do that. And that's a lesson I learned very early in one of the deals when I was in-house counsel, trying to guide business people. They had had gotten a couple of free trips in connection with this license agreement. I'm like, why didn't you ask for 4? There's 4 people on the team. Why did you only ask for 3? And I got very, very nicely back. Look, just be the scrivener. Yeah, just do the deal, get it done. Don't worry about business terms. We've got that taken care of. And it's a humbling reminder at times, and I don't know how you guys deal with this, but when you're outside of work, and I've said this before, you have to remember you are someone removed from the deal, right? So you've got, internally, you've got a business person, you perhaps got an in-house lawyer, and then you're the outside lawyer. So by the time it gets to you, know that some of the business issues that you may think are novel, unique, and you may think can add value, someone probably has thought of them. So I'm not saying you raise them, but when someone comes back to you and says, hey, look, we got this covered, understand that's why. It's not a knock on you, it's just, hey, look, we've got that bit, we're hiring you for your business.
And that kind of dovetails into something that, as I write for Forbes, we see in the sports world every day there's what I call crisis management going on in all levels. And so you bring up something, being general counsel, coming basically outside and having kind of I don't want to say it's a completely dispassionate view, but you're certainly sitting after others have looked at it and can give kind of a fresh view of it. But I mean, it does really get into the kind of the nuts and bolts of this as a business attorney. How do you identify and manage risk for your company in the midst of those kind of negotiations? Let's start with known enemies.
You do that a number of ways. I mean, our job as lawyers is to issue stuff, right? And so, it's just that instinctive thing. And I think, part of the way we do that is by staying informed, broadly and specifically to the particular issue, particular industry, but also, one of the things that I do, in addition to my transactional practices, that I chair the risk management committee for the organization. So just keeping an eye on all potential risk across the board, whether it's a legal risk, a financial risk, a reputational risk. In addition to that, legislative issues, so constantly on the watch for what's happening with the legislature that may come down and affect us. And do this broadly, also from a contractual perspective. So as you move through contracts, our job is to find out what could go wrong. What's the downside here, and to think about all of that in advance, and certainly I found the litigation perspective has helped me with that. But you really have to look carefully and consider everything that could go wrong. And it's not a fatalistic view, it's just a very necessary one to protect the client's interests.
I don't know if I have too much to add to that. I think part of it is we get to deal with certain things that are repeat, sponsorship agreement or licensing arrangement or something on the employee side. And so after a certain amount of time, you've seen that kind of thing before, so you can understand the inherent risks with it. And a lot of that comes with experience, and also studying and reading. It's amazing what you can find if you Google what are the risks of a sponsorship agreement. I mean, you can find out a lot of stuff, and because there's so many great forums and people talking and publishing, and so you can really bring it up. But there's always something new, and there's also just remembering, like you mentioned, reputational risk. And it was a good reminder that everybody's running around and doing their business part. It's a revenue producer who's trying to sell this thing to make money, or it's the marketing person just wants to get this project done, and impact whatever we're trying to measure, hits on the website or whatever we're doing, ratings points for the TV, and so people are thinking about stuff, but there's not always somebody kind of connecting the dots. And I found that my role is, is to do that sometimes, and not to babysit people, to be heavy-handed, or to meddle in people's business, but just to take a step back, that all these things need to be part of the global plan, and just some little extra thought and common sense that anyone could have done. That we're not unique, but just being in a position and really being able to just think about it for a second. And the question raised is, are we going to get sued necessarily? Or is somebody going to get hurt, or we lose millions of dollars? But just a little bit of like, we worked so hard to roll this thing out, and there's just this little thing, little nagging bit that if we didn't think about could unravel the whole thing. And not because it's a legal issue, but just because just thinking about the timing of a press release, or when do we're in this promotion for what about the other sponsors that we're supposed to be taking care of? How's this going to impact them? Just kind of, and as a lawyer, I'm aware of this because I just worked on that other sponsor's sponsorship agreement. Whereas the marketing folks may not even know that sponsor exists yet. So it's just sort of, it's all these little things, and just trying to keep the dots connected.
I kind of jumped ahead on that answer, sorry for part of this. One thing that I'll add is, when I think of, my practice is primarily transaction, and I kind of have an interesting hybrid practice where I'm partially outside counsel, but I'm also special counsel if needed. So I'm acting in an in-house role, but I also have clients and I serve as outside counsel too. But the one thing I always think of in terms of risk is, I always think, and maybe I'm paranoid, but I always think of how's the other side trying to screw me? And especially with language, when I review language and I'm looking at language agreements, I think, okay, how could the other side try to twist this language to get a better position? And I won't ask Ben to comment on this, but the NBA is filled with lawyers, okay, from top to bottom, okay. And I remember a lawyer that had left the NBA telling me a story that they would sit around in their meetings when they talked about drafting their contracts, and they would literally have a table full of lawyers, and they would say things as finite as, if we move this comma from here to here, we can argue this. And so, it's a good lesson because it makes you think of how important language is, that we, that is our tool. We are, authors of great works that, works that are selling at, Amazon, but that's what we do. We get paid for works. So think of how you use them. That's my kind of risk mitigation.
And that kind of dovetails into this. So we heard this a bit in the last panel, which I thought was fantastic, especially on the sponsorship side. There are always risks and rewards from sponsorship deals. I'm looking at it from two perspectives right now, and as a member of the media. There's certainly an outgrowth of sponsorship deals, certainly naming rights in arenas, in stadium or in arena advertisement opportunities. And then there are the sponsorship deals that go on with individual players within an apparel company and whatnot. And there are, of course, inherent risks involved. On the player side, of course, we're seeing certain things where the player is involved in performance-enhancing drugs or what have you. They get involved in some kind of scandal. There's the risk that comes on there and how that is basically addressed. But, what is the process really in the negotiating, managing, and sustaining of sponsorship deals, both at the club level and then, of course, at the global apparel level? I'll let you guys flip a coin this time.
All right. Okay. This is actually something that we're talking about internally a lot right now with our sponsorship group. I think if you want to just get mechanical about it, the deal often when it comes to my desk is a list of bullet points of stuff we're supposed to give. And so if someone wants to have a brand affiliation with us, and we're going to give them, 2 30-second commercials in, Comcast and some radio spots, and some digital signage and a promotion, giveaway, handout thingy, and whatever, and they're going to pay us some money, and we're going to sign it. And probably the vast majority of the deals that come across, and actually we've actually constructed our process, our contract process, so that type of business, right? There's a template for the sponsorship folks to use that they can fill in these assets, they can fill in the money, when the money's going to get paid, and we're going to attach it to some pretty standard legal bits in the back, and so that if they've done their job and we attach the right stuff, we're done. And we send it over to the sponsor, and 9 times out of 10, they just sign it and send it back. So there's just not this negotiation, there's not this arduous process, and I think that's actually a detriment in a lot of ways, because you have some sales folks that well-meaning, really qualified, great sales folks that love our staff, go out to whatever business and say, hey, you want to be affiliated with us, here's a bunch of stuff, and they say, oh, you're right, I do want to be affiliated with you, here's some money, yay, and then a season goes by, and we're doing a wrap up with these folks, and maybe some money's still outstanding, and the sponsor says, I'm not really just sure we got our value here. And we say, well, listen, there's a checklist here, and we've ticked off all the stuff. All your commercials were delivered, and your web ad impressions, and we had players show up at your shop, and it's all here. And so we delivered on exactly what we said we would, which sounds like the essence of a contract and a deal. But it actually isn't enough. And part of it goes back to the first conversations that our sponsor sales folks are having with these potential sponsors. Why do you want to be affiliated with us? What are you trying to get out of this? What is the measurable impact on your business? How are you going to know that this has been successful? And have that articulated and documented and sometimes built back into the contract. I mean, we're not afraid of having something in the contract that says we're going to generate X click-through on our web ads. We're going to generate a certain number of ratings points. We're going to have, hand out X number of things. Let's start getting some quantifiable things on here. And also, let's be partners about this, so that it's not. So I'm very sensitive now to a 1 year deal. If something comes by in 1 year, or just 1 year, I'm not confident that we're going to be able to deliver for them, because we don't have a second year to readapt and be better for them. But a 3 or 5 year deal says, we're in this together. Maybe we don't know what this is going to look like. What exactly we're going to feel this out, and we're going to be in it together. And year 2 might look totally different than year 1 in terms of the products and the deliverables, but we'll be happy. And so it's really we're trying to head back to just the core business things, that a deal is what the parties understand and expect, and a bullet point list of things is not always the best description and encapsulation of that. And so let's have some extra conversations. So it's not just me throwing a contract that's super thorough and has totally accounted for every single risk, so the sponsor doesn't want to pay us. I can hammer them 50 ways and send it to collections, because it's just not going to really result in anybody being happy, or it's a lot of extra time for our business. So now it's me working in conjunction with other business partners. We're working with the sponsorship folks so that deals are understood from the beginning and communicated from the beginning, because they're just humans interacting with each other, and throwing them kind of the piece of paper that says, well, actually, here's our rights and here's yours, doesn't solve the problem most of the time.
No.
So our process is similar, but a little bit different. It's really all about getting the deal on paper and activation ultimately, and that's the same. There are some differences that are driven by the league, frankly. I work both the NBA team and the MLB team, and for both of them at the same time. One of the challenges is, knowing what the different leagues do and do not permit. And for example, with Major League Baseball, we don't have the right to sell our interactive media rights. All of those are only the league level. So if somebody is part of their sponsorship deal with us wants interactive media rights, we do all the other rights to our sponsorship agreement, and then facilitate an agreement with them, between them and Major League Baseball for interactive media rights. So it's not always a cut and dry. Sometimes we have to bring the league in. But we draft all the sponsorship agreements. I also have the benefit of having a larger staff. We have an associate general counsel and an assistant, and also have an intern 3 quarters of the year. But our associate general counsel drafts all the sponsorship agreements. That's his primary area of responsibility now, and I look at them if they're 5 years or longer. Otherwise, unless he has a particular issue, I don't necessarily see them anymore. But what we have done is that we have a lengthy template that has all the different elements, and we have a very creative corporate sales group, and we have a lot of different elements to sell. What I've seen change over the years is the number of sponsorship elements available, because you will sell anything you can put a name or a logo, and we do, and we have. So we have that, and then what we have done is standard terms and conditions that really has become, one of those boilerplate columnar sheets that we attach to the bag. It's 2 or 3 pages, and part of our strategy for that, frankly, was that if we did it that way, that people would be less inclined to want to negotiate it, because it's the small print and all that. It still happens. So occasionally has to fight with it. Certain parts are non-negotiable. We have Major League Baseball subservience language, completely non-negotiable. Sort of battles we have about things like that all the time, but for the most part, they get signed. Some of them take longer than usual. I think we have more multi-year deals than anything else. We also have the complication, it's a good problem to have, but of having spring training as a part of that. And we partner with the Colorado Rockies at our spring training facility, and because we're local, we really sell the sponsorships on behalf of both the clubs. So then we have to deal with, in terms of the agreement itself, if it's an agreement that incorporates spring training, how do we incorporate that into the agreement without sharing our proprietary information for our regular sponsorship sales with the Rockies? So we worked over on that with an attachment, but otherwise, it's all about activation and the way our corporate sales department is structured. There's a sales team, and then there's the account executives that follow up with activation, and they have very, very close relationships with the sponsors. They stay in close contact with them. This business is all about relationships. I don't care what area of the business it is, and our corporate salespeople are very, very good at that. And one of the things that we started this year, a couple of years ago now, a lot of companies used to do B2B summits to build those relationships and share best practices and get their sponsors to essentially compete against each other to be the best and spend the most money. And what we implemented, I think 3 years ago, was the MVP awards. So it's like this, the Oscars of corporate sales, and it's literally like that. It's this whole stage event, the red carpet. We get the MVP awards out to the different sponsors and the dancing and singing and all that. But it's really about thinking outside the box to maximize your corporate partner relationships and revenues.
I didn't believe you had the NBA to ask if you want to jump on that. I'll answer from a different perspective. So, in my special counsel role, I do both the sports work and the entertainment work. So, I'll introduce an entertainment answer on this one. If you look at kind of the process of aligning the Adidas brand with an entertainer, it starts with seeding. And so, as a lawyer, I have no piece of that puzzle. So, we have an office in Portland, office in LA that does seeding, and an office in London that does seeding. As artists go through those areas, those folks seed product out and seed product internationally to people. So no legal piece of that, no agreement with any of those folks. Purely, I'm going to give you product. If you wear it, great. If you don't want to wear it, you don't wear it. It's kind of the next level up is where I get involved, which is, okay, we'd like for you to do an appearance for us. And that appearance could be, we'd like for you to appear at our All-Star party. Okay, so let's take New Orleans, where we had 2 Chainz appear. Snoop sponsored party. He was kind of the host. We had 2 Chainz, DJ Mustard, Jeezy got up on stage, YG, Break, all these folks. So we do typically a very short, we heard one of the other panelists earlier talk about kind of a very short form appearance agreement. It's just that you appear at the event. We're going to sponsor you for that moment in time. We've got certain rights around performance there, not the musical rights, but we've got certain rights around your image. So I'll work on kind of that piece of the sponsorship is involved there. Then as you move along kind of the spectrum, I'll give you an example of what we do with the CLE, where we actually created a line with her, and it was a kind of, not only a sponsorship relationship, an endorsement relationship, but we also had the licensing piece where we went deeper. So that's kind of the next stage where I get involved. And then kind of the penultimate stage is kind of, I think, what we did recently with Kanye West, where we kind of merged him with the brand, where he truly is, he's one of those folks, you talk, I think it was one of the panelists earlier talking about folks trying to cross over he is a fashionista. I mean, he actually, I've been in the room with him when he talks about fashion, and I can see he actually knows fashion really well. I was actually really impressed with his depth of knowledge and what he talked about. So that's kind of the extent of that. No one talked about it, though, you talked about the relationships. This is our business is really relationship driven, especially at Adidas. If you think about our relationships with our entertainers, with our great athletes, whether it's Derrick Rose or Damian Lillard, those are areas where it's important that you as a lawyer remember kind of the end game. And I think it's the same with the team, right? Those teams want to sponsor money. And we as a sponsor, we team, we're one of those sponsors. We get something out of that relationship. But as a lawyer, I think you have to remember to always see the end game, which is Adidas wants to have a relationship with Damian Lillard. It's not, it's not the lawyer's place to overreach to avoid that. It seems like my comments continually are asking lawyers to kind of pull back. I'm not asking you to completely pull back, but just to think about where you are. And Governor Ben talked about, there's a bigger picture here. There's a bigger picture of the process. We're part of a bigger team. That's kind of the approach on the sponsorship side.
I think it's a real kind of tension. You talk about the skill set because you don't want to get in the way of the deal happening. But sometimes you're equipped to ask the questions that people sell into each other haven't wanted to ask each other because let's figure it out down the road. And that's when things go south. And because it is a relationship thing, the contract is the contract, and the relationship is the relationship. So sometimes being able to nudge people towards those important conversations early without scuttling a deal in any way. And I think that goes to courage thing to talk about. It's another sort of courage moment. Just in terms of, I might have different kind of levels on the endorsement side, that Nona and I deal with. Because I've known you for 20 minutes now. For us, we have kind of entry level sponsors, 1 year, try to get them multiple years, and then you get into some brand exclusivities. We have Wells Fargo, they're our exclusive financial partner in the arena right now, and there's people paying more for these definitions, and so there can be a lot of fun negotiation around. Well, what does it mean to be a financial partner? Because that can be incredibly expansive. Then, of course, we put naming rights on the building this past summer. And that was a really fun deal working with Moda and the general counsel over there. And it was something that seems intuitive, like, well, you put naming rights in this building, so you should have exclusivity for health insurance. Well, what does that mean? Because that's, you think health these days is, it's such a growing and expansive industry. The next step to the side is wellness. Well, what's wellness? And now you're into potentially Nordic tracks and and green smoothies and whatever. Just everything can be tied into health and wellness. And so really figuring out what that space is, and not in an adversarial way, but what you guys need to protect. Help us protect you while while we can continue to have avenues to sell to other people who want to partner with us. And those are the really fun conversations.
Mention the scope of exclusivity as well, because I think this is probably true for you too, that at some level, you can't sell what we don't have. And we also have to give deference to the league's exclusive sponsorships. I'll trump anything that we're going to do because they have the national sponsorships, so we really have to be careful with the scope of exclusivity, not just the particular area of sponsorship.
Great stuff. We've got about 20 minutes left. I want to shift gears. I come from mostly a baseball side, covered the NFL quite a bit. One of the things that we're obviously seeing a huge story, a huge legal and certainly financial impact to sports is the matter of concussions. And this, I know that we're talking about this from the club level. We can talk about, certainly the leagues are going to look at their policies around how concussion operates. So if it's baseball, we currently have a deal now where we're implementing an experimental rule with collisions to the plate. The NFL is dealing with a host of issues. Some might say reactively, but they're trying to get proactively out in front of it. But the venues themselves, and the clubs themselves have different things. Baseball especially. I don't know how many times I've seen a ball flying into the stands, or you see a bat. There was a huge conversation around maple bats and how they were breaking, and then, the liability that goes along with that. So, around that potential concussion issue, is there anything that teams can do, or the leagues itself, and we'll expand this to really kind of help prevent the lawsuits that might come from it? And I don't like to start with you. You get the baseball money, you're doing so good on this stuff.
Well, I think you already mentioned Major League Baseball. I think that's a huge step, especially when it comes to concussions and other debilitating injuries. The other thing I think that is really more at a league-wide level is, in addition to changing rules, is what technology can help available from a health perspective that can help protect against some of those injuries and stay on top of that. When you talk about the other liability issues, that's always something of great interest, particularly in baseball, because we're always concerned about the safety of our fans. We are. And we do everything we can to protect them. Baseball is unique, at least in many jurisdictions, certainly in Arizona, because we have statutory protection from liability for baseball, for bats and balls and things that we ordinarily expect to fly into the stands. And it's really an assumption of the risk policy more than anything else. And in addition to that, you make the announcements and put things up on your for us as TV, the Jumbotron, letting people know that, hey, there's a risk. Watch for flying. We have signs everywhere. Watch for flying out there to the field. We give people warnings ahead of time. We offer to move them if we need to. Other things I guess you could do to avoid those types of injuries is, you can expand the net more goals, but at what point does that become unreasonable? And the other reasonable duty to protect our fans from harm. We have to protect ourselves too. And that's what the baseball, the protection from baseball liability was about. But, you also have to be careful in the context of the game and the rest of the league. For example, if one facility was to put nets around the entire lower bowl, does that raise the bar for every other club? And do they then have to do it, or they want to state liability? So it's not that cut and dry, unfortunately, for that particular issue. But I think the leagues do what they can to protect the players, and certainly the leagues can protect the fans. And that also extends to, the concourses and other areas of the building as well. So, I think this one is
Sure.
back.
Yeah, Paul, you just laughed at us, just smile.
It's
It's all your folks are going to sue us later. So. No, I think concussions get all the attention right now because of some of the high-profile cases, the recent settlement and non-approval of the settlement. But I think that's just one example of the general thing of how do you deal with players who get hurt in the course of doing their sport. So there's not been a lot of high-profile concussion things for the NBA, but you see a former NBA player 10 years later, and they're walking pretty stiff sometimes. There's a lot of knee injuries. There's a lot of things that happen that then go straight into the same kind of funnel of what sort of compensation should there be or shouldn't there be after the fact of this playing time and this contract and this closed employment situation that has after effects down the road. And I think the concussions lawsuits are an example of perhaps that stuff hadn't been fully vetted and negotiated within that contract. And so the players, at least that, players want to come back and say, well, no, there's more going on than just you pay me to play football. The big example for us, we have a lot of workers' compensation claims that come back for knees. And the big hook for us was California, cumulative trauma. And so basically, California, so Oregon has a statute of limitations about injuries that, within a year of knowing the basis for an injury from an employment claim you have to file that claim with the employer, or then it's time barred. It centers around discrete injuries. You know, I hurt my hand on the job, I hurt my leg on the job. And California was built differently, had this doctrine of cumulative trauma, this idea that, okay, a lot of harm aren't discrete injuries, but are the accumulation of impact over a long period of time. And years and years and years after that employment, you can still file in California, even if you only played one game of your career in California. Then that liability will then get spread among all the other teams and places that you did play. And just a few months ago, there was legislation passed in California changing that law to exempt sports teams. You know, it wasn't meant to help highly compensated sports professionals. It was something, you know, people who've done hard labor for a long period of time, probably have been compensated well for it. But, you know, so they changed laws. So that's really going to reduce a lot of the financial and administrative burden on leagues and teams trying to deal with players, you know, because I get claims from folks who played in 1978. And, you know, I think leagues are trying to approach this fairly and equitably. And, you know, I think we all kind of see some common sense to making sure that, you know, that players have an avenue for continued relief. You know, those are things that can be dealt with in unions and, you know, the pool of money that the players share among themselves. And so I think the conversations are good, but they just kind of go to the core of this economic deal that's taking place for someone to put their body on the line and getting paid for it. And, you know, concussions are just the most visible example right now.
We want to add two things to that. One is on a local level, if you think about what's happening here in Oregon. 2009, the Oregon legislature passed a law with respect to high school students and concussions in high school. This passed legislative session, not the one we're currently in, but there's a law that just went into effect in January that now takes that kind of protections with students that have concussions down to all levels. So you're seeing legislation at the state level. People are looking at this issue and trying to legislate deal with it. And even there's concussion issues in other sports. Eddie Johnson, I believe, Portland Timbers, right, sued the Timbers in MLS for concussions he sustained, not in games, but in practice, and saying, look, you let me practice when I have concussion. Or I'm sorry, he sued saying, you let me practice when I have concussion. I don't know where the litigation is, but so you're seeing, I don't know where that litigation is, but you're seeing activity even in other sports around this issue.
How are we doing, Tom? Good. Great. One of the things that I want to talk about from the global apparel side of things, and from the club side, you know, is there a growing need in sports law to protect clubs and manufacturers from crisis standpoints from off-the-field matters? We continue to see high visibility players, whether it's, you know, around sports itself, or I talked earlier about whether it's certainly in baseball, we have Alex Rodriguez, and there's been some conversation on whether it's collectively bargaining around whether players can get out of player contracts, and there's this conversation. But it really boils down to there's a host of other things. I mean, if you have an athlete that's part of a sponsorship deal and they get embroiled in some kind of situation, then you start to talk about whether that contract is somehow no longer valuable. So there's this it seems to be increasing on a number of levels. The league's trying to do stuff about it. There's certainly a lot of work, I think, at the player level, certainly at the agent level, that they need to inject themselves. But really, do you see a growing need to have that conversation with the clubs or with the athletes or entertainers that you're involved with to try and ferret that out either in advance or what kind of situations you can do to address that proactively?
Moral spots headed to it.
Yeah.
I love when you do this. This is my favorite Paul spiel.
So in each of the deals that we do, there is a morals clause, right? And this is the clause that basically says you're going to live clean living, right? This is the clean living clause, right? No drugs, no adverse publicity, nothing strange. It's a tension for us as a brand, and I'll talk about both sides. When you work with someone like Snoop Dogg, right? Snoop smokes a lot of weed, full stop, right? Typically in all of our deals, we have a provision that says you won't use drugs. That's a provision that we have to deal with when we have a relationship with someone like Snoop. Adidas has a relationship with Justin Bieber. Justin Bieber's gotten in a lot of trouble lately, right? There's been a lot of bad stuff that's been out. So how do you as a brand address that issue of, do you take the step of terminating the relationship? That's generally what the relief is termination. And I'm not speaking just as the other particular, I'm talking about industry-wide, whether it's Adidas or Reebok, Puma, Under Armour, Nike, that's conceptually what it is, Red Bull, T-Mobile, even non-athletic brands. How do you deal with that? How do you deal with fan backlash, right? Justin Bieber's fans are not running from him at this moment. Some of them have embraced him and said he's being targeted, he's being properly persecuted. How do you as a brand decide what you're going to do or not do? On the sports side, right, you've seen even this week, or let's say the past, I'm going to say 2 weeks, you have the kid from Oklahoma State, right, push the fan. You had New Mexico State, I believe that was last night, the melee at the end of the game. You had the kid throw the ball and the kids throwing punches at each other, right? I watched that this morning at Sports Center. That was great. Raymond Felton, you got to watch him walk out, last because he had a gun. We've had to deal with issues we've done before, Gilbert Arenas, right? Took a gun into an NBA arena, which is not only problematic from a federal and state law perspective, but it's problematic from a team rules perspective, right? You're not supposed to have guns inside the arena. Can you imagine why, right? It seems like it's a problem for a player bringing guns inside the arena. It just doesn't seem like a problem. So it's those sorts of things that you as a brand walk the line with. What I will say in every deal that you do, you have that provision negotiated in one way or another because it's an important piece of deciding when does an athlete cross the line that your brand no longer wants that association or affiliation. We had an athlete out of Europe who threatened a ref and then made very derogatory comments about what he planned to do to the ref's daughter. And immediately we terminated that athlete because that's not who you want your brand to be associated with. That's not who you want as a face of
And more we deal with more sponsors from the sponsor perspective, especially sponsors who spend a great deal of money with us. They want to be sure if something goes wrong, that would be embarrassing to them, that they have an opportunity to terminate the agreement. So when we come across those, we try to, if we're going to have to agree to it to get the deal done, try to construe it as narrowly as possible and have to address whatever their real concern may be and not have it be overly broad so that if and be sure it's something that causes public embarrassment as opposed to something that tends to cause public embarrassment. So just have to be very careful with drafting those. And, we also try and put some, in the uniform player contract, most of it can't be negotiated. It's not negotiable. However, the guarantee language and the special covenants can be negotiated. And we try to put some language that's akin to a morals clause in the players' contracts in those areas where if they engage in certain prohibited conduct or, or be convicted of certain crimes and things, we have at least the ability to convert the contract from a guaranteed contract to a non-guaranteed contract. In some cases, the ability to terminate the contract with approval of the commissioner's office. So I think, especially in this day and age, with everything that has happened, especially in the last few years with high-profile athletes, that it's critical to have these and we just see people now.
That's great. The only thing I'd add, just the union aspect of this, like Mona said, it's hard to negotiate this with an athlete. Paul has the luxury of giving his player a bunch of money, setting out some pretty good expectations, and being able to enforce it without someone else stepping in and saying, no, you can't do that. And any real action on this has to take place at the league and union level, which then we just kind of illustrates being an in-house lawyer for a team where your influence responsibilities start and end. You have a player that works for as an employee for your team. It's just kind of funny to think about. I mean, this gets a check out of the payroll department, just like I do, and the person in sponsorship. It's all part of the same payroll system. So they're an employee of the team, but they are out there being visible and doing stuff, and sometimes get into trouble. And the first instinct, the first call, sometimes is call call me. Or the PR, call the PR person, and the PR person would call me, on a Saturday night, and I'll be into my third rum and coke, and that's not where you want to be at that moment. But it happens, and then what are you supposed to do as the in-house lawyer? Because there's a moment there where you're advising an employee of the company who needs some help, and that's what in-house lawyers do in any industry. But at the same time, there becomes a moment where the company's interest, the team's interest diverges from this player's interest and his responsibilities. And depending on the nature of what's happening, who's involved, it can happen really quickly. And then making sure that we at all times, we have to keep our code of ethics. And it's a core part of what we do. And it can be a little bit more fluid in the in-house context. Sitting in a firm, you know who your client is, and you know how to vigorously support them and advocate for them. And so, kind of understanding, communicating, so that people can keep that in perspective, while not being, you can't just at the first phone call say, well, I'm not your lawyer, and so I'm not going to help you. But finding a way to make sure they are getting the input that they need, but you can still be a helpful resource.
One thing, it makes it easier now as brand owners because there are cameras everywhere. Hello, University of Oregon football team, the snowball fight. Hello, Johnny football. I mean, stuff does not get missed nowadays. It just doesn't.
So, fantastic. I have to say, I'm very pleased that I got invited to do this. This whole panel has been fantastic. What I did see, I didn't see all of it. I think we're going to open this up now for questions and answers. Who would like to do? Am I walking with you, Mike? Would you like this final word?
I thought the question that you had about interviews, I thought that was really fascinating. And I'm curious, from the inside, what type of technologies, how are you using technology to help aid in this discussion and help that move this forward? I don't care who answers.
I can answer this one. So I get to answer one question, so even though I'm already so I cover sports business from the outside, not from a lawyer's perspective. We can go to baseball again. So one of the chief concerns, of course, is, and Paul, I think, will speak to this as well, is that the leagues are working closely with manufacturers to try and address and mitigate without removing the essence of the game. And this is a key part of what I think is at stake here right now, football especially, a very violent sport. And how do we protect the employees of a club and of a league while still keeping the essence of the game? I often worry about the NBA, when you see players get upended and there's no protection. That in baseball right now, we're seeing a change in pitchers' counts. They look bulky, they look kind of funky right now, but they're basically working with New Era and Spalding and other manufacturers to try and design something that protects balls that come back up the middle and hit pitchers, where you have a split second to basically try and protect yourself if the ball comes up the middle. So I think that what I am seeing in contacts with my league contacts and club contacts, of course, is that they're looking at it, I think, from the ability to keep the essence of the game. Nona talked about this earlier with the fans. And there's some conversations about whether balls should be tossed back into the crowd, and whether that protects them, and that fine line that goes on. But I think that you will always see technology, and thank goodness the apparel makers are really at the forefront of this. I think that they're very much ahead of this, trying to provide that, and whether it's the leagues driving that and saying we want more protection to either promote the longevity of athletes or to protect themselves from a liability perspective, whether it's these, where we have these class action lawsuits. Either way, what you're doing is you have an asset in the athlete that are seeking higher and higher amounts of money. They're an asset, whether it's, we have Buster Posey being taken out for a season, so play collisions, and whether rules are implemented or whether there's a change in the technology around the equipment that's being used by players.
The one thing, we don't make helmets, it's So one thing in our area, if you look at kind of the head issue, which is driving it, where we do a lot is with FIFA, because we're the leading soccer brand. So there's a lot there that goes on, both with our AIT group as well as with our group in Germany, working on that bit. We also have relationships with partners, so Athletes Performance, I was talking to Noah about this, it's a well-known athletic training company based in Phoenix. Adidas has a relationship with Athletes Performance, they're actually one of my clients also, and they do a lot around this. They work actually with private players, we have LPA, so that piece of it, there's a certain extent that Adidas does, but it's not as deep as some of the helmet manufacturers and the other folks.
Oh, thanks so much. I wanted to ask, push you on the morals clause, and have you comment on this for a second, because it occurs to me that different people's morals can be very different. You talk about drugs and clean living and don't embarrass the brand. We've got states now where marijuana is perfectly legal, and we've got many people in the country who think that's good. We've got many people who don't. You've got players coming out as openly gay. You've got gay marriage perfectly legal in large parts of the country, as I think is wonderful. But you've got large fan bases who I'm sure think that's not a good thing or not been supportive of that social change. How do you balance this? And how do you balance your own morals versus the morals of your fan base?
That's a good question. Fortunately, our fan base, I'll say fortunately or unfortunately, our fan base is large, right? We are going to offend some consumers with our actions. I guarantee. Assume, let's take Gilbert Arenas as an example. I'm sure someone out there felt that the action that we took with respect to Gilbert was punitive and that we shouldn't have, and that what he did wasn't bad enough that he should have lost his deal. Whereas I think the majority of people with the athlete that I mentioned in Europe who made those comments to the rep, I think that's a tough one to have anyone defend. It truly is, I think, at the brands, and this is a reality, I think, it comes down to who's in the senior management positions, because they're the ones who ultimately are deciding what the brand stands for and what those values are. And, whether it's someone, I guarantee if Phil might see something with a Nike athlete that would cross a line that he found personally repugnant, that's how the morals clause is going to be interpreted. It's the same thing here. When we have people in Germany that see things, that's how that view is taken. It's tough, it's usually, fortunately for us, the cases that we've seen, it's been very clear cut. And we've been able to, it hasn't been a stretch. But I can see areas where there is going to be disagreement. So for example, right now, RG3 is one of our key athletes. He plays for the Washington Redskins. I personally think that name is one of the most repugnant, racist names in the world. We've got him on the team, right? Should he step up and say something about that issue? Again, this is me personally. This is not me talking about computers. Does his affiliation with that brand somehow tarnish his value to us? It's tough.
People are fight back. You get a morals clause.
We do get fight backs. We do get fight back. And traditionally, where we get fight back is from someone who's had problems. Where I start to worry is when someone challenges that clause and they try to kind of water it down. It's like, really? Come on, the guy's committed a felony? We've had them, and we've had people do silly things. We've had athletes that have gone through customs with marijuana wrapped in tinfoil, and we've seen some silly stuff. But yeah, that it always worries me when people push back on that.
Any other questions?
So you mentioned that you sort of have to work around with the league, being above you and working within that. atmosphere. With the recent change in commissioners in the NBA and a possible different view of how the league will, the future and whatnot, how have you had to respond with that?
That's a really good question. We actually just got a memo half an hour before I started here talking about the new structure of the legal department and that cascades down from Adam Silver and folks that were heading up key legal positions now, key management positions, and so it's definitely changing. I think we'll see how it goes. We had league meetings last May. All the team lawyers get together every other year and try to share best practices, and so that was last May. And Adam Silver spoke and kind of I think tried to give a little bit of preview and tone for how things will look going forward. And I think the key takeaway for me was collaboration. I think folks who practiced at teams 15, 20 years ago might not have described the relationship with the NBA as highly collaborative, or even among the teams, because these are teams that are competing with each other for players and for money and for titles, and I think there's a kind of a much clearer understanding that we're all part of a 30-team association and with a tie that lists everybody, and that if we for sure compete on the floor and for sure try to compete with players, but outside of that, really can be sharing a lot and supporting each other. And I think the league's taking that tone as well. So sending out memos, trying to share best practices, and there's still an enforcement aspect. We have the constitutional bylaws and ops manual this thick. That's only the and at the end it says these aren't even all the rules, and those rules include rules that say the rules are whatever we say they are. So they will always have some aspect of that. So they do, I don't like getting a call from 212 area code at 9 a.m. after a game, because it means we probably didn't do something right and telling us about it. But even then, outside of kind of egregious acts, it's going to be collaborative. We're just trying to work together to support each other, protect each other, build the league, and I think Adam Silver is really pushing that, and that's because he went to University of Chicago. Just a plug.
All right, that's the end of our business law panel. I'd like to thank all of our